use to fund their sales. So I guess just go to the next slide, Abby. Okay, so why should you defend repossession cases? I think of all of the consumer type of debt defense that I do, I get more sort of bang for my buck in defending auto repossession and deficiency cases because the code, Uniform Commercial Code, really gives consumers a lot of defenses that have a realistic chance of succeeding as opposed to other type of debts like, maybe credit card debt or student loan debt or things like that. Just sort of anecdotally, I think I do more good for the amount of time that I can spend on a case for a consumer who's been sued on an auto debt than I can for maybe consumers that have been sued by credit card companies and debt buyers of credit card debts and things like that. So if you're looking to do pro bono cases, I think this area of the law can be really satisfying because you can make your clients happy. Sometimes these companies will voluntarily dismiss lawsuits, and they may not satisfy the underlying debt on people's credit reports or things like that, but it can be a relief to people that, if they lose a debt auto deficiency case and they have a judgment entered against them, then they may be looking at having a wage garnishment, having a checking account garnished, or if they decide to do a bankruptcy at that point, they've got to deal with the fact that the judgment or the deficiency has been reduced to a judgment, which can be a little tougher in bankruptcies than just your typical unsecured debt. So this is an area that you can really help out a client if you're considering taking these on pro bono. Will you go back one slide, Abby? I think there was something else I was supposed to talk about. Okay, so how to approach defending a deficiency action. The first part of the CLE, I'm going to basically take you through or give you some ideas about how to just defend a garden variety repossession action. We'll talk a little bit about some things that you may hear from your client that are, in my experience, what I would call sort of one-off circumstances that you won't see a lot, but in talking to other consumer advocates, at conferences and things like that, I know these one-off things do happen, and it's just something to keep an eye out for. And I wanted to mention one thing that we really don't have time to cover today that I'll speak about briefly now, is that sometimes your clients will come in and the dealer that they purchased the car from will have done something that, it might violate the Truth in Lending Act. It might violate the Arkansas Deceptive Trade Practices Act. They may have been sold a salvaged vehicle. They may have been sold, or there just may be any number of misrepresentations can occur from the dealer. When you see that in something really bad has happened from the dealer and you're investigating, whether or anything about that, one thing you need to remember is that you can bring that claim say a Deceptive Trade Practices Act claim or a TILA claim against the finance company, and you can recover from the finance company that sued the that has filed the auto deficiency action. You can recover damages from that finance company up to the amount your client has paid the finance company, and potentially the down payment in attorney's fees. So let's say, for instance, your client has made 6 months of monthly payments and you know the dealership did something that violated the Deceptive Trade Practices Act or another statute, or committed fraud even, you can file a counterclaim in the deficiency action. And at the very, very least, the finance company is on the hook to give your client credit for like the 6 monthly payments. There's a little bit of dispute about whether you can get attorney's fees and down payments and things like that back. We don't really have time to go into that today. I just want you to be aware that you can bring the counterclaim against the dealer, the counterclaim against the direct finance company or the credit union or whoever's suing if the dealer did something to violate the law. The general way that you want to approach defending these deficiency actions is to force, say, a credit union or an indirect finance company like Credit Acceptance to prove that the sale of the vehicle itself after the repossession is commercially reasonable. How I have won cases at trial before is simply pointing out to the court that the finance company has not brought anybody to trial as a witness from the auto auction that can testify about things like the condition of the vehicle, how many bids there were at the auction, did they advertise this particular sale, how many people actually showed up at the auction, whether it was an online auction or an in-person auction. And you can win a deficiency case just based on pointing out to the judge that the finance company doesn't have anybody at trial with personal knowledge about how the sale actually happened. And that's particularly effective if you look at the retail installment contract and you see that, for example, this dealership and your client agreed that this car was worth, say $20,000 in January. Your client defaulted after 6 months and it's repossessed. And then say the car only sold at auction for $7,000. And now the finance company or the credit union or the bank's wanting $13,000. In my experience, judges really will pay attention when there is a large gap between the amount of money that was paid at the sale of the vehicle, because everybody agrees that's the fair market value of the vehicle. And then just a few months later, you're selling the car at the auction for, 60% less than that. And those kind of facts tend to get the judge's attention. But you can quite easily win cases for your clients if you just take the approach in a garden variety repossession and deficiency judgment case that the credit union or the finance company has not met their burden of proof with personal knowledge about what happened at the sale of the vehicle and how that sale was conducted. And you can get traction with your judges by pointing that out. So there's plenty of case law that you can just pull up the code in Westlaw or whatever and look at the annotations about, plaintiffs not having personal knowledge and at trial or bringing a witness that can testify about how the sales happened. And that's a very easy way to win a case. So that is, and I'd be happy to walk anybody through that. Just call me if you want to do that, but that's basically your garden variety repossession case and how to defend it. Okay, next slide. All right, so I'm going to go through the basic UCC framework. A creditor can seize your client's car. They don't have to go to court. Okay. So the other thing you want to point out to the judge at a trial is that the UCC gives the creditor this pretty ordinary remedy that they don't have to go to court and get a court order to seize your client's property. That is an extrajudicial remedy that you don't find in a lot of areas of the law. And since the code, the Uniform Commercial Code in Article 9 gives the creditor that right, shouldn't they be held to account when they don't follow the rep code to get a judgment, or excuse me, to get a deficiency judgment against your client. That's the trade-off. And if you frame that issue to the judges that you're going to appear in front of, most judges tend to think, yeah, you know what? These creditors, the finance companies, the credit unions, they don't have to ask anybody's permission to go out and seize the vehicle. So shouldn't they follow the UCC after they repossess the vehicle? And if they don't, maybe, you know, your client doesn't have to pay them anymore because they're getting money at the sale of the vehicle. So you want to paint that picture to the judge. You know, this is the trade-off. The credit union, the finance companies can seize collateral without a court order, but shouldn't they be held to account when they don't follow the Uniform Commercial Code that literally every state has adopted in some form to get a deficiency judgment against your clients? All right, so that's kind of what you want to paint the picture to the judge. So when they dispose of collateral after default, they have to do it in a commercially reasonable manner. That's what I just talked about. Every aspect of the disposition of collateral must be commercially reasonable. So what does that mean? When they dispose of the collateral, they have to send out a notice that they're going to dispose of the collateral to your client. From that point forward, everything the creditor does must be commercially reasonable. And when you raise that defense in your answer as an affirmative defense, that burden of proof shifts to the creditor to prove that everything they did from that moment through the disposition of the collateral to when they send your client the explanation of calculation of deficiency, all of that has to be done in a commercially reasonable way. And they have to prove it, okay? They have the burden of proving that, even though it won't say it in their complaint, they still have the burden of proving commercial reasonableness. Okay, next slide. Okay, the first thing the creditor has to do. Oh no, this is after the sale. So this after the sale, the creditor has to send a notice to your client that about what they owe, what they don't owe if there's a surplus. Okay, so this is the second notice that after the sale. They have to state the amount of deficiency. If it's a surplus, it's in the surplus. Hardly ever happens. If it is happening, I'm not hearing about it because people are getting checks and they never call an attorney. But for the most part, there's going to be deficiencies in 99% of the cases. So they have to explain in accordance with the UCC how they calculated the deficiency. Okay, and part of that explanation is there may be in the future debits, credits, credit service charges, interest, expenses about that may affect the surplus or the deficiency. Okay, and they also have to provide telephone number, mailing address about how to get additional information. And we'll look a little bit later because this can to counterclaim and things like that can help your clients out. Okay, next slide. Okay, so this is the notice portion that a creditor has to include before they sell the vehicle. So we got slides a little bit out of order. That's okay. So this is in the notice that your client gets immediately after repossession, pretty soon after repossession. The notice has to contain these things. It has to describe the debtor with the client. Okay, it has to be sent to the right person. They can't send it mom, they can't send it to dad. They have to be sure that they send it to the correct address. I literally just this week I've picked up a case where it appears the notice was sent to my client's childhood home where she hasn't lived since she was 18. The retail installment contract has her current or the address at the time she purchased the vehicle. it was repossessed from a home that she moved to later, and for some reason they sent the note to the home she grew up in, and we're going to file a defense on that and counterclaim. But anyway, it's got to describe the debtor and the secured party who is sending the notice. There are cases where the secured party does not really identify themselves. They identify an affiliated entity. They may describe themselves generically, and it's not the actual secured party. So that happened. I've not seen it happen in Arkansas yet. I have seen it happen in other states, and I know attorneys who have brought claims notice a disposition was incorrect because the secured party wasn't identified in the notice. You have to describe the collateral. Typically what is the year, make, and model, probably the VIN number, but it's not enough that they say, hey, we took something from you, or we took something from you and now we're going to sell it. So it has to describe the collateral in some manner. There's actually a form notice of disposition in the code itself that you can look at and see the way to do it, I guess, or the suggested way to do it. It has to state the method of intended disposition. What does that mean? That means the creditor has to tell the debtor, your client, if they're going to sell this vehicle at a private sale or at a public sale. A private sale is typically going to be like at Manheim, Odessa. Some Arkansas vehicles are taken over to Memphis. I forget the name of the auction house over there. Some are taken to Fort Worth or Oklahoma. But if the notice says that this vehicle is going to be sold at a public sale, they have to state, like it says in E, the time, place of the public disposition, or the time after which the disposition is to be made. So the reason that's in the code is there's this idea that your debtor, your client, can show up at the auction and bid on the vehicle, or they may, theoretically have other people show up or advertise the disposition so that there's more bidders at the sale. That's usually not going to happen. It happens every once in a while, 1 out of 200 times or so. But so the notice has to state, is this a private sale or is this a public sale? A private sale is going to be, for example, like when America's Car-Mart, when they repossess a car, they're going to do a private sale and they're going to return the car. For the most part, they're going to return the car to their inventory and put it back on the lot. And they're not going to sell it, for 10 days, and then it's going to be offered to the public. So that would be, even though it's sitting on their lot, that's a quote unquote private sale. If it's a private sale, they don't have to state, we're going to sell it at this date and location, because it's a private sale. What you will sometimes see happen at dealerships that do in-house financing is they will advertise these sales as public, and they're really not public sales because that dealership winds up buying the car back themselves. And that is a big red flag if you find out in discovery that the dealership is doing a self-finance and the self-finance dealership buys the car back themselves. Because typically what they will do, what I've seen happen, is after 10 days, they'll buy all the cars that they've repossessed for basically the same price, $4,000, $5,000. And if you get into discovery and you cross-examine their witnesses at trial, you'll find out that they pretty much buy back their own cars. And that's really not a quote unquote public sale. That's really an insider sale. If you get an insider sale, your client shouldn't have a deficiency judgment entered against them, because that's really not a public sale. The other thing is they have to state that your client is entitled to an accounting of the indebtedness and state the charge that they're going to charge if they want an accounting. Some notices, this is relatively new in Article 9. It was added when the Uniform Commercial Code was amended, I think in 2009. And you will still see notices out there that don't say anything about your client being entitled to an accounting and how to go about getting that, who to write to get, and what is charged for an accounting. So those are the things to look out for when you look at the notices. Some notices sometimes are attached to the complaint and you'll have it. Most of the time, your clients won't have it. They will have lost it. Sometimes you'll get an organized client that's kept the notices in a file or something, and you can look them over. Sometimes you have to get them in discovery, but they have to send these notices. So if they don't produce the notice, then they can't get a deficiency. Okay, next slide. Okay, so the set-off theory is, go back one. Yeah, so the set-off theory, if your client gets a faulty notice, either of these notices, if they get a faulty pre-sale notice about how they're going to dispose of the collateral, the code entitles your client to statutory damages, and we'll go through that in a minute. And it's typically the entire finance charge in the contract plus 10% of the principal. A lot of times that number will be greater than the deficiency your client has been sued for, or it gets real close to satisfying the deficiency. Even if, we'll talk about the absolute bar approach later. So that is a counterclaim you can bring, or a set-off you can bring for your client. If the post-sale notice that explains the surplus or the deficiency is defective in some way, the code provides a $500 statutory damages that you can use as a set-off or a counterclaim. So that's how you bring the set-off theory, or that's how you use the set-off theory. Okay, next slide. All right, so these are sort of the one-offs that you'll hear about every once in a while that will preclude a deficiency. The payment to the assignee, basically, if a contract's assigned and basically the payment from the sale satisfies the debt, obviously there's no deficiency. Sometimes your clients will tell you a story about, they said if they took this car back, they wouldn't, they wouldn't sue them for the debt or something like that. That's usually not going to be in writing. That's usually going to be a he said, she said. But if you can prove that a dealership said, hey, we'll take your car back, we're not going to sue you, you're probably going to have a swearing match. But if they promise to accept the collateral back in satisfaction of the debt, then that's enforceable, and that meaning that they can't get a deficiency. If your client revoked acceptance of the vehicle, in other words, the client goes to an auto dealer and for whatever reason, there's a salvage title, the car is not in the condition as promised, and they've sent an actual revocation of acceptance letter under the Uniform Commercial Code, and they revoked acceptance. Dealers can't get a deficiency after that. In Arkansas, they can get a deficiency. Some states limit the deficiency's amount pretty severely, but Arkansas, you can get a deficiency. So there's not an absolute bar on deficiencies. The wrongful use of collateral, you will see this at some small dealers. The dealer takes the car back and they drive it around for 2 or 3 years, just as, going back and forth to get parts for cars or whatever. They're just using it, and then they sell it, and then they sue your client for a deficiency. That does happen. I've had that happen before. I talked to a lady, I guess a month ago, where it took the dealer 2 years to sell the vehicle, and we suspect that's probably what was happening. They were just using the vehicle. Wrongful use of collateral can also come in, like obviously if your client is current on the loan and it gets repossessed, which does happen for various reasons, that would be wrongful use and a wrongful repossession. So there's not going to be a deficiency there. If the car is abandoned and is worthless, in other words, they don't sell the vehicle, they have to go out and try to sell it. But if the car has been totaled or something like that, and it's just sitting at a junkyard and they're not going to try to sell it, they can't get a deficiency. And I talked about the delay in sale of the collateral. They have to, at some point, they have to sell the thing. If they're going to wait 2 years and then sell it, you're not going to be able to get a deficiency. Those are sort of your exceptional cases that do come up every once in a while. Okay, next slide. We talked about this. Sometimes creditors will lead the consumer to believe that they can return the debt in that, return the collateral and the debt won't be pursued. That does happen. Typically, like I said, that's going to be a swearing match between your client and somebody at the dealership or the finance company. And you're going to have to convince the judge about your client's credibility. But I've had clients tell me that, and either my clients may have been telling the truth, or maybe they didn't quite understand what was being said on the phone calls, but that does happen. Okay, next slide. Okay, so what you want to tell the judge about the absolute bar rule. Before 2009, if the sale of the vehicle was not commercially reasonable, if the notice that was sent out by the finance company or the credit union did not comply with the Uniform Commercial Code, if it didn't have those 5 or 6 things identified in the notice, all of the Arkansas was very strong on this. That meant that there was no way that the finance company, the credit union, could get a deficiency against your client. The law said there is an absolute bar to a deficiency. So it's just a hard line. Whatever the creditor got at the sale of the vehicle, that's all they're ever going to get. Your client absolutely doesn't owe the debt. He doesn't owe the deficiency. It shouldn't be a balance reported on their credit report at that point, and there should be a judgment entered in favor of your client that they don't owe the debt. Okay. Since the code was amended in 2009, and other states have shifted to what is called a rebuttable presumption theory, depending on at what point in the sale the acting unreasonable happened. And unfortunately, I think there is one bankruptcy case that kind of goes into this rebuttable presumption theory. It's from a bankruptcy court in Arkansas, and it doesn't quite say Arkansas is a rebuttable presumption state. And I don't think, from reading the opinion, the attorneys asked the court to squarely address that issue. But basically, what a rebuttable presumption is that it's not an absolute bar if the sale didn't go down commercial reasonableness. At that point, what some states say is there is a presumption that the amount of money that the creditor got at the sale of the vehicle satisfies the debt, but the creditor can then put on evidence that a deficiency is still owed. So you have to be aware of that, because there are some other states since 2009 that go that route. And usually what it will look like is, oh, judge, our notices that we sent to the client before we sold the vehicle, maybe they weren't quite right, and they didn't have all those things. Like, we didn't tell the client that they were entitled to an accounting, but everything else about the sale of the vehicle was commercially reasonable. We've got this evidence that the auction happened at this time, and there were this many bids, and whatever it is that they'll say they acted reasonably, because they will try to rebut the presumption that the amount of money that they got at the sale satisfied the debt. So that's how that works. And I did have one creditor argue this to the judge at trial, and it did not work. He went with the absolute bar because their notices were faulty about whether it was a public or private sale. So we don't really quite know whether we're going to do rebuttable presumptions in Arkansas going forward. It hasn't gone up to the Arkansas Court of Appeals or the Arkansas Supreme Court the last time I looked. But the way I handle that is, judge, we've always been an absolute bar state. Nothing in the revised Article 9 of the Uniform Commercial Code says differently. So we're still an absolute bar state. And until we get the Court of Appeals or the Arkansas Supreme Court saying differently, then I do think we're an absolute bar state. So that's how you have to approach approach that. So what you want to tell the judge is, if they didn't act commercially reasonable, there's an absolute bar to deficiency. And that's still the law in Arkansas. Okay, next slide. Okay, so that's how you defend basically a garden variety repossession case. You want to focus on the personal knowledge of the dealer. You want to focus on the notices and make sure that everything complies with the Uniform Commercial Code. Hold the plaintiff's feet to the fire, that they have to bring somebody with personal knowledge about how the sale was conducted. So what I'll talk about now for 15, 20 minutes or so is how to review a notice and what to look for. So this is a notice that we're litigating now. This was sent to my client. And if you'll look on here, what we're griping about in this notice is they say in the notice that this vehicle was going to be sold at a public sale at Dealers Auto Auction in Memphis on a certain day. Our issue is Dealers Auto Auction in Memphis does not sell these vehicles to the public. They only sell these cars that Arkansas Federal Credit Union repossesses to dealers. This is a dealers only auction in Memphis that they take their cars to. So if you went up to this auction, if you could find it, they also don't have the location and the time, which they're supposed to have in the notice. But say, you went online and you said, okay, Dealers Auto Auction is, on whatever, Shelby Drive in Memphis. I'm going to go over there and see when the sale's going to happen. They wouldn't let you in the door because you're not a wholesale dealer. So it's not a public sale. It's a private sale. It's a dealer only sale. And a dealer only sale is a private sale. So this notice should have said, we're going to sell this, on April 26th at a private sale. So this notice, should be enough for the judge to rule that this is an absolute bar and my client doesn't have to pay this deficiency that they're going to say he owes. Okay, so that's why you have to look at these notices very carefully. So when you see things like Dealers Auto Auction, Odessa, Mannheim, those are not public sales. Those are dealer only sales. The only people that can bid at those sales are auto wholesale dealers. Okay, so that's what you want to look out for. One of the things you want to look out for. Okay, next slide. All right, so when you see that, when you see a notice that was sent out before the sale and you think, gosh, I remember what Corey was talking about, you pull up the code section, you look for those 5 or 6 things and you're like, wow, they messed this notice up. You got to go back to the retail installment contract, and we'll look at another one here in a second. This is the second notice on there on the left that Arkansas Federal Credit Union sent to my client. This is after they sold the vehicle. Okay. And if you remember, they have to tell the client or your client and their customer and the consumer how they calculated the deficiency. So if you look at this post-sale notice, this is their explanation of the deficiency. You see that my client before the sale owed $14,900. When any rebates that he got credited for, they got $10,000 for it at auction, which is actually pretty good. So they've sued him for $4,700. But if you look down on that one that I highlighted on the left, you see that it says extended warranty and gap premium refunds. They didn't give him any credit for that. So you got to go and you pull out the retail installment contract that's usually attached to the complaint, or you can get in discovery, or a client should have it. And if you go over and this is the second page on the right of my client's retail installment contract. And if you notice right there, over the course of this loan, I think it was for either 5 years or 6 years, part of the financing included a $3,100 service contract from, I forget which company it was from. Well, when my client defaulted on the loan and he couldn't, pay for this car anymore, he's not making, none of his monthly payments are going to pay this service contract, this $3,100 for the service contract. Well, the credit union is not entitled to get a judgment in that amount. So the judgment amounts that they're asking for is inflated. If my client's got a $400 monthly payment, a portion of that is going to pay for this service contract, and he's no longer paying for this service contract because the car's been repossessed. Well, the code says that they have to credit back. They don't have to do it right now and say they're going to do it in the future, but they do have to credit back to my client that amount of money that he hasn't paid for the service contract. So say he's paid in his monthly payments, $300 towards his service contract. Well, they have to give that back in G. That's highlighted on the left. They should have credited him back, $2,800 because he hadn't paid $2,800 for the service contract. So in that case, they should have sued him for $4,771 or whatever, or $5,241 less $2,800. So when this happens, and if you see something like this happen in the explanation of deficiency, the code says that your client has a $500 statutory damages claim against the plaintiff, against, in this case, the credit union. So you can file that as a counterclaim in your action, or you can ask for a set off and say, Judge, my client agreed to pay $3,100 for the service contract. He didn't pay it. They've got to credit this back. And the code now provides a statutory damages of $500 for my client. Okay, so that's what you want to look for. Something you want to look for in the explanation of deficiency is whether there was gap purchased, a service contract, extended warranty, and that has to be credited back against the deficiency. Okay, next slide. Okay, so I'll use this notice to show you the statutory damages that can your client can be entitled to when the notice that is sent out before the sale of the vehicle doesn't comply with the UCC. So this is a credit union notice that my client got. And if you see there on the left, you'll see these notices every once in a while that the credit union or the finance company will say, hey, we're going to sell this vehicle at a public or a private sale in 10 days. Okay, this does not comply with the UCC, because if they decide to sell this thing at a public sale, they have to tell your client where that public sale is going to happen. They have to tell your client what day it's going to happen, and they have to tell your client what time it's going to happen. All right. To be a valid public sale, your client has to have that information. So that part of the notice does not comply with the UCC. And this is, again, the notice that was sent out before the sale of the vehicle. And if you read the entire notice, you'll also notice, you also realize that they did not explicitly tell my client that they were entitled to an accounting of the debt. So if you read that last sentence, if you can see it, it says, if you need additional information, call or write. Okay, well, what does that mean? It doesn't say that they're entitled to an accounting. It just says, if you want some more information, give us a call. That's not sufficient under the UCC. So they haven't told my client that they're entitled to an accounting of the indebtedness. So when that happens and you have this defective notice, what section 625 of the UCC says is that your client's entitled to statutory damages. And there is a method for calculating statutory damages that is basically what it amounts to is your client is entitled to the finance charge in the contract. So you pull out the contract. This is a credit union loan liner agreement. I don't remember how much. I think it's $3,600 is the finance charge or something like that. So your client's entitled to that $3,600 plus 10% of the principal. The principal is the amount financed in the TILA disclosures. So all the contracts should have your TILA disclosures, okay? So my client in this case is entitled to the $3,600 in the finance charge plus 10% of the amount financed, which in this case looks to be just over $1,400. You add those two together, my client's entitled to get a little over $5,000 from the credit union because their notices are not good. And if you go back to the part where we talked about the absolute bar, this notice also means my client, they can't get a deficiency against my client because this notice is not commercially reasonable for two reasons. They didn't tell my client that they were entitled to an accounting. They didn't tell them whether it would be a public or private sale. If it's a public sale, my client's entitled to know where that sale's taking place, when it's taking place, and the notice is defective. So in this case, you got for your client is the credit union can't collect a deficiency against them, and you should be demanding that they pay these statutory damages. And if you tell and I'm telling you, if you tell your client, if you find one of these cases and you tell your client, I think I can explain to them, obviously that no guarantees in litigation, but you may be able to get out of this debt, get it off your credit report and put money in your pocket, then they're going to think that you're a really great lawyer. Because most of the clients are trying to figure out how can I at least, get out from under this debt, or, can they take something off the debt? Can I get a payment plan? That's usually what they're thinking. But in a case like this, you're really going to do a lot of good for your client. So that's why it's important to look at all these notices, the retail installment contract, and listen pretty carefully to what your client's telling you about the debt itself. Okay, next slide. We've talked about this a little bit. When the disposition is defective, the creditor has the burden of proving that it was commercially reasonable. They can't do that. There's an absolute bar, no deficiency. You should have a judgment at the least entered in favor of your client that they don't owe this deficiency. At that point, it should come off their credit report. If it doesn't, you can send the judgment to the credit reporting agencies and say, hey, my client doesn't owe this money, take it off. If they don't take it off, then you can, sue the creditor under the federal Fair Credit Reporting Act and the credit reporting agencies because you've got a judgment. The consumer remedies, I just went over this, the statutory damages that your client might be entitled to if these notices show that the sale wasn't commercially reasonable. So that can be a really effective remedy that frankly a lot of attorneys don't know about, but it's literally right in the code. It's in section 625 of the code. All right, next slide. Now, this is what I just talked about. This is how you calculate the statutory damages when the top part, section B there, that is how you calculate the statutory damages when the notice that is sent before the sale of the vehicle is defective, or they didn't act in a commercially reasonable way, or even if like there was a wrongful repossession. Okay, we didn't cover wrongful repossessions. Your client's current, they repossess the car anyway. At the very least, they're entitled to 10% of the principal plus the entire finance charge. That's in the top part where it says B2. That's what that B2 means. It's not worded explicitly, but that's what it means. You get the finance charge plus 10% of the principal if it wasn't a commercially reasonable sale or if the notice before the sale was defective. Section E, which is below that, if you look at 5 and 6, if a creditor fails to comply with section 616, B1 or B2, that's the case where they did not credit my client for the unpaid part of the service contract. You get $500. So if you look at the contract and it says, hey, there's an extended warranty, there's a gap premium, there's any one of these number of financial products the dealer sold my client, My client didn't pay, it was repossessed, but they didn't give him credit for the remainder of what was owed for the service contract, then you have a $500 counterclaim that you can bring. So that's why you pull out the explanation that your client got after the sale of the vehicle. That's a $500 statutory claim. And usually it's going to be a part of pattern or consistent with a practice. Usually it's going to be, they've done this to everybody, so it's usually going to be a pattern. But your client's entitled to $500. So at least you get the $500 set off, or you can show the judge that, this plaintiff that's filed the lawsuit is kind of asleep at the wheel about complying with the UCC. The other, they violate these other provisions, 208, 209, 509, 513. Really don't have the time to go into that today, but that can happen too. So that's the statutory damages that a lot of attorneys don't know about that are now in the Uniform Commercial Code since it was amended. And they're really powerful. So next slide. Statute of limitations is a big issue in Arkansas because the Uniform Commercial Code for sale of goods, the statute of limitations is only 4 years. Most attorneys in Arkansas operate under the assumption that if there is a written contract, then the statute of limitations is 5 years. That's not true for a sale of goods. It's in the code. It's in, I forget which section it is, but it is a 4-year statute of limitation from default, not from the time that the car was sold, not from the time that the car was repossessed, not from the time they sent one of the 2 notices, from the time your client missed that last payment. That's when the statute of limitations starts to run. And I see this, for the most part, I'll see this when a debt buyer buys the debt and they file a lawsuit between the 4 and 5 years. And I've got Judge Wright to dismiss a case in Pulaski County against 2 clients where a debt buyer bought an auto deficiency debt. I think it was from Santander, and they sued after 4 years, but before the 5 years was up. And Judge Wright thought, yeah, you're right. The UCC is a 4-year statute of limitations, and he dismissed the case with prejudice on statute of limitations. And he made it pay my client, or no, he hadn't ruled on that. I filed a motion for attorney's fees after that because it was dismissed with prejudice. Some judges, and the flip side of that, I had a judge in, I think it was Jefferson County, filed a same motion to dismiss. She denied the Rule 12 motion to dismiss and said she would decide it at trial. So anyway, look out for that. When did your client default? If they filed the lawsuit more than 4 years after your client defaulted, you can file a Rule 12 motion, or at very least raise it in your answer that statute of limitations bars the claim. All right, next slide. One thing I wanted to mention about the statute of limitations, if it's a debt buyer that sued your client past the statute of limitations and you get it dismissed, you have an FDCPA claim against the debt buyer. So you can go sue the debt buyer for your client for a Fair Debt Collection Practices Act violation, for an Arkansas Fair Debt Collection Practices Act violation, and your client's entitled to get emotional distress damages if they have it. They have to pay your attorney fees, and they can and $1,000 in statutory damages. Talked about that. Okay, next slide. Other defenses. It's a plaintiff the correct party. We talked about that a little bit. Sometimes they won't quite identify themselves. They may identify themselves as a debt buyer. Did they actually buy the debt? Y'all can do all those defenses. They have to prove up a chain of title. The venue requirement. The only place that a consumer can be sued on a debt is in the county that they reside at the time the lawsuit was filed, or where they signed the contract. So you have to watch out for that. Sometimes you'll have a venue issue that you can move the venue to the right county. We talked about the elements the creditors must prove. That's whether the sale was commercially reasonable. All right, next slide. Okay, that's it. if you have any questions, call me. My email is cmcgahay@mcgahay.law, or, reach out to me, reach out to Abby. She'll put you in touch with me. Happy to help. The first time I met Abby, we were both defending a deficiency case in Garland County. She was defending a client for legal aid, and I was defending a case for somebody that had hired me to defend the case. I think we both won, so it was kind of nice to see.
Yes, there on a statute of limitations issue, and I think you were there on a notice issue. And if I remember correctly, these attorneys did not put anything about the accounting in their notice, and the judge was basically like, "You guys have no excuse. There's literally a form notice right there, in the in the code. Like, you have no excuse." And he completely prevented them from getting any deficiency judgment.
Yeah, and
that was cool.
Yeah, it was pretty cool. And like I said, these cases tend to be like, the judge will look at these cases and be like, okay, the finance company got some money at the sale of the vehicle. They're not complying with the UCC. Why do they get a deficiency? And most judges seem to they pay attention to your presentation of how they should have acted under the UCC, I think. So, and I'll be happy to answer any questions.
I don't see any coming up, but I will, just so we can fill our time, I'll ask a question.
Yeah.
Okay. So when you have cases like this, or when you get a case and you see that, like in that case, in the instance that I'm talking about that happened in Garland County, where that this dealership in this particular scenario did not give a proper notice, does that kind of tip you off to look out for clients who have dealt with this particular dealer?
Yeah, because what will happen is any dealer that has, this was an auto dealer, any dealer that's doing this as part of their business, they're going to have somebody that's doing the same thing over and over again. And that's what you'll that's what you'll typically find, is that these notices are meant to run kind of like a machine. And so if they're making one mistake in a notice, they've probably made a mistake in multiple notices. And so, like in the case that Abby was talking about, we were in district court, so you can't really bring a counterclaim to district court. We got the case dismissed, and then we sued the car dealership for my client's statutory damages and got those from my client after the case. If you're in circuit court, you can bring it as a counterclaim. And we've got the Diamond Lakes and the Arkansas Federal Credit Union cases we filed as class action counterclaims. So we're litigating the Arkansas Fair Credit now. We settled the Diamond Lakes as a class action that's been preliminarily approved. So it's a pattern in practice almost always, if the notices are defective.
We have a question from Cecile. I don't know if you've met her, but she also works for Center for Arkansas Legal Services. And she deals with this kind of stuff a lot. And she wants to know, how would you argue that the statute of limitation for a contract for sale is distinguishable from a deficiency balance?
Say that again.
Or, as in contracts for sale equals present sale of goods and a contract to sell goods at a future time versus secured action or one-time transaction?
I don't think I've ever had to argue that. I mean, I don't know if I've ever had anybody bring that up. So I'll have to think about that. I don't know. Sorry.
I think she might be referring to the same issue that we had that one day that we were talking about earlier.
Statute of limitations issue?
Yeah, I think she may be talking about.
Okay. So yeah. So
I can actually let her clarify. I can allow her to talk, and then she can ask it.
Okay. So I'll answer that question because it's important. Okay. I don't know if if that's what she meant, but so there's a line of cases. It's like Ozark Capital. I forget the citation, but there's a line of statutory construction cases, not only in Arkansas or in other states too, that if you have two competing statutes, like, you all know that a lawsuit to enforce a written instrument is a 5-year statute of limitations. The UCC says a contract for the sale of goods is a 4-year statute of limitations. And so when the court looks at that, the court should, under this rule of statutory construction, apply the most specific statute to the facts of the case. In other words, the retail installment contracts are written instruments and they're written contracts, but it's specific to a contract for the sale of goods. The goods is obviously the car or the truck or whatever. So it's always the most specific statute that controls. And there's a Arkansas Supreme Court on that concept of statutory construction. The other thing you can do is tell the court that every other state that's decided that issue has decided it in favor of the UCC controlling, or the shorter statute of limitations controlling. And there's Cecile knows there's a NCLC manual that talks about this issue, and I'd be happy to share that with people. But literally, and one of the things I think that Judge Ohm was asking Abby was, well, surely Arkansas has decided this issue. And we're like, no, they haven't, because we know they haven't. We have to tell you what every other state has done. But every other state says the shorter time frame controls.
Yeah. Cecile also wants to know, do plaintiffs usually attach the notices given to their complaint? Or do you get these in discovery?
Oh, Cecile, it's usually about 2/3, I think, attach at least the first notice that they give before the sale. So you'll see a lot of credit acceptance cases. They'll usually attach the contract in the first notice, maybe the second one. Not all of them do. Like JD Byrider, their finance company does not. They attach like some form that, shows what the deficiency is, but it's not a notice. So you have to get those from your client or get them in discovery. So I probably about 2/3, I think, probably attach one of the notices or both the notices or the notices in the contract. So you may have to get them in discovery.
Okay. We do have one more question here from Marie Crawford, and she has a hypo actually. She says, okay, so lender meets all the notice and repossession requirements, but commits violations with other acts, like did not purchase the gap policy, did not secure service contract, or did not provide buyer with copy of the contract. Then what?
Okay, so there is something called the FTC holder rule. The FTC, the Fair Trade Commission, which is a federal government entity, has something called the holder rule. I talked about it a little bit at the beginning of the CLE. What the holder rule says is the holder of a contract for the sale of goods that's a consumer good is responsible for the actions of the dealership or the original creditor. So if the dealership did something like charged your client for a gap, charged your client for the service contract, but they didn't actually buy that contract, you can enforce your client's damages against the plaintiff in the deficiency action up to the amount your client actually paid to the finance company. And this happens all the time. So usually what I will do is file a counterclaim under the holder rule against the finance company and let them know the dealer did some bad stuff. And you can get a set off against the finance company. There isn't dispute about whether you can get your attorney's fees for bringing that counterclaim or any down payments that your client made to the dealer, but you can at least get the monthly payments as a set off. And then while on a case like that, I would actually sue the dealership. What I will do if the dealership's acting funny or doing something like that, and I can prove it, if it's a used car dealer, I will send a FOIA request to the Arkansas State Police, and they have to give me all the dealer licensing and consumer complaints that's been filed against the dealer before. And they usually do that within like a week and see how bad they're acting. And if it's something like that, I mean, that's basically fraud. If your client's paying for a gap policy, a service contract, You may have a defense of rescission of the contract, or illegality is an affirmative defense. Fraud in the infactum is an affirmative defense. If they're paying for all these things as part of the benefit of the bargain, you may be able to convince the court that the contract should be rescinded. So those are just some ideas. I don't know how much money you've got at stake that might, determine whether you sue the dealership. But I sue dealerships all the time after I've filed an answer, a deficiency answer. So don't be afraid to do that.